Sure. Hi, I'm Mike McCarthy, and thank you for joining us for this special conversation here on YouTube today. I'm joined today by former Franklin County Prosecutor Ron O'Brien. He served in the office for more than 20 years. You were the longest serving prosecutor ever in Franklin County, so you know a thing or two about the law.
Yes. So thank you for inviting me to be with you.
So we're talking to you today because we are seeing a new development today in a case we're following very closely, and that is the double homicide of the Tepes that happened 3 weeks ago, Spencer Tepe and his wife Monique Tepe. And today, about an hour ago, the suspect in those killings, Michael McKee, the ex-husband of Monique, faced a judge for the very first time here in Franklin County. And before we really get into the details of this hearing, I think we should just give everyone a very basic recap of where this case stands. This is something we have been following for about 3 weeks now, and Michael McKee is the ex-husband of Monique Tepe, who was killed back on December 30th in her Wineland Park home along with her current husband, Spencer. Michael McKee has been charged with 5 counts. They include 4 counts of aggravated murder and 1 count of aggravated burglary. He was arrested in Rockford, Illinois. That's where he was working, and he was living in the Chicago area. And investigators here in Columbus, with Columbus Police, were able to track him down to Chicago. He was taken into custody there and just brought back here to Franklin County earlier this week. And that leads us now to today and the first hearing in this case here in Franklin County. It was an arraignment, and as you know, these hearings are often very procedural and very quick. This one was certainly both of those things. This lasted roughly a minute, and the defense in this case entered not guilty pleas to all the charges. But when it came to bond, which is typically the biggest decision that often comes out of these hearings, the defense waived the right to bond in this case. So he will remain behind bars right now, no bond set at all. Why do you think the defense would make that move? Why not ask for a bond at all?
Well, first, the party that conducted the arraignment for the court was Mark Petrucci, who's a magistrate. He's not an elected judge.
Okay.
And judges will, because I guess arraignments are somewhat of a drudgery within the court system, they have their magistrates do arraignments. And whatever bond that he might set is subject to an appeal to a judge. And actually, the case will be assigned to a judge now that not guilty pleas have been entered, probably either later today or even Monday. And it'll be assigned to a judge, and whatever bond that he would set today would be subject, as Ms. Manacci said, at the arraignment, she reserved the right to ask for a bond. So what typically happens when you can expect or predict a high bond by the magistrate, where you either have an appeal or ask the judge to reduce it, she just passed on bond and is going to take the issue of bond up once the case is assigned to one of the 17 judges there.
And the she you're referring to is Diane Manasci, who is Michael McKee's defense attorney, just so folks watching us can understand.
And Diane is a very experienced defense attorney. Has been around for probably 20-plus years, handled very high-profile cases, and is a good trial lawyer. And as you know, actually, I had predicted before she was announced as a retained attorney that she might be one of the attorneys that McKee would select.
Really?
Yeah.
What about her background makes her a good choice, you think?
Well, she's handled a lot of high-profile cases and has had success, at least in a number of them, avoiding a death sentence. The defendant was found guilty. I can think of 3 death penalty cases I tried against her. She does a good job. 2 of those 3 were murders of police officers. The Reagan-Tokes case that was very highly publicized, OSU student kidnapped, raped, and murdered. She represented him in a 3-week trial down in Common Pleas Court. So she has a very good background as a defense attorney, does a good job, is very aggressive in representing her clients, and as I say, she would be one of the top defense attorneys I guest would be retained in the case because I didn't think as a surgeon the defendant will qualify for public defender.
Sure, and that's a good point that we should have brought up already. Michael McKee is a surgeon working there in Chicago. When you talk about the defense attorney, I know another case folks would probably remember her for recently is she was one of the attorneys who helped defend William Husel, which was an indictment that you brought as well, and he was acquitted of the charges in that case in the patient deaths there at Mount Carmel.
Right. He was acquitted. That case was indicted when I was still prosecutor, and then it was tried maybe 2 years later after I had left. And there was a dismissal of about half the cases, and the others that they tried were acquittals across the board.
So we'll turn our attention back to this particular case now. And the 5 counts that Michael McKee faces, as I mentioned, 4 counts of aggravated murder, 1 count of aggravated burglary. Something that stood out to us in this indictment is the fact that all those counts do include a gun specification with a detail that, frankly, I've not seen that often in cases, is there's a specification in there that a silencer was used on the weapon. 2 questions. What would be the significance of that gun specification being added? Why would you want to do that when you seek an indictment? And also, why reveal the detail about the silencer so early in the investigation with the indictment?
The reason you would do that is to enhance the penalty. The legislature has, going back to 1996, created specifications for violent crimes that are committed with firearms. There's a 1-year gun spec. That means if you commit a burglary or robbery and have a gun but don't waive it or use it in the commission of the crime, you get 1 more mandatory year of sentence tacked on to what you might get otherwise. If you use the gun in the course of the crime, it's a 3-year gun spec. There is a 6-year gun spec that applies if you use a firearm that has a silencer or suppressor on it. And then you also have a spec for an automatic weapon, thinking that if you're committing a crime with firearms, using a suppressor to avoid detection, you should be penalized more. And that's what the legislature decided. And you don't often see, as you say, the silencer spec, but apparently one was used in this case, and certainly if you're the prosecutor, you're going to include the silencer spec if you have it.
So when we look at overall court proceedings and arraignments, which happen at the start of every case, was there anything in this case, the proceeding today, that stood out to you that was unusual, something you didn't expect, or was it all pretty fundamentally basic legal work there in the courtroom today?
Right. I think it was exactly as anyone who has observed the court system or been in it would expect. You have a right to have the indictment read to you. That's always waived because you don't want the judge sitting up on the bench reading 3 pages of legal mumbo jumbo to you, consuming 5 minutes. So the indictment reading was waived. Time of service, you have to have 24 hours from the time you're indicted and given a copy of it before you can be required to be arraigned. That's standard that you waive that. And then the only remaining issue is no one pleads guilty in this county to at an arraignment. They don't have, the defense doesn't have discovery yet. The state probably hasn't spent time with the victim yet to find out what is an appropriate plea. So 99.99% of the people plead not guilty at arraignment. And then the real issue that gets addressed at arraignment is bond, which, as we talked about before, was passed on.
McKee said nothing in court today. Again, it was a brief hearing, but again, that's not unusual. Defendants rarely speak at an arraignment.
Right. The only time I can think they may is on the issue of bond, where the lawyer may ask them, do you have a place to go? Do you have a job? If let out, will you come back to court? Those kind of things are the only couple things that, and it's very, very rare the defendant themselves speaks. Some judges require the defendant themselves to enter the not guilty plea. But at least in this county, the attorneys, whether it's a public defender or private counsel, generally say the defendant enters a not guilty plea.
So we are very early on in this. As I mentioned, December 30th this is when these two tragic murders happened, the arrest earlier this month, and now the start of the legal process. I would like to get your insights on how this all could move ahead, and the emphasis there on could, because obviously you are not involved in this case. I want to make that very clear, but with your legal expertise, would you mind if we had a couple more questions about, as we look ahead, what could happen here?
Sure.
I'm curious, if you were still in the prosecutor's office, knowing what you know about this case, where do you start to build your case to seek a conviction?
Well, hopefully it started long ago, shortly after the homicide. It had a fair amount of publicity, as you know. The prosecutor's office should have been working with the police from the get-go on what they had, what they didn't have. There may have been things that they needed legal process for. Before his indictment, before his arrest, they filed a complaint in municipal court, and the complaint was for simple murder rather than aggravated murder. Why that choice was made, I don't know, but they have to prepare an affidavit to support the issuance of the arrest warrant, which was done in this case. So hopefully the prosecutor's office was working with the police all the way back then, and if there was a preparation of the facts for the search warrant in Cook County, even though it would be a search warrant issued in Cook County, the prosecutor here wants to make sure that search warrant's good. And any evidence that's seized, which I understand from the chief, the murder weapon was seized up there, and hopefully it was done with a search warrant, and hopefully the search warrant, the prosecutor's office helped prepare the search warrant and the affidavit for it, because the worst thing that could happen in this case is that any evidence that they seized up there might be suppressed because the search warrant's insufficient. So in this kind of case, the prosecutor should have been up from the get-go involved, helping the police make sure they're building a good, legally sufficient case. And at least from this point forward, they'll be working with Ms. Menashe, who will ask for a couple things: a bill of particulars, which more in detail fleshes out what the charges are, and asked for discovery, which there's a whole list under the criminal rules of items the prosecution has to give to the defense to prepare for the trial. Any statements that he may have made, any past criminal record he may have, a witness list, lab tests. Obviously, if they seize the gun, what they'll do is ballistics tests on the bullets removed at the autopsy, an autopsy report, 2 of them. All those things the prosecutor will be collecting and providing to the defense, and also reviewing them themselves to make sure that there's nothing more that may need to be done. I think that I saw or heard that shell casings were found at the scene. You can get DNA off of shell casings. So if I put the casings in the clip and it was a semi-automatic weapon and the shells were ejected, then if they're collected at the scene, my DNA from putting the shell in the clip might be detectable. So there's some lab tests that either should have been done, and if not done, the prosecutor will ask to be done in order to build that case.
What do you think of the evidence so far? You mentioned the weapon that was used. Columbus police have said that they found the weapon that they believe was used in this murder, or these 2 murders, in McKee's home, along with a number of other firearms. They also say they initially looked at him and began tracking him down, or at least they said they did that, because they noticed a car that was seen coming and going from the Wineland Park neighborhood around the time of the killings, and then they ended up tracing that car back to Illinois, linking it to Michael McKee, and then he is now in custody. So you have, according to police, you have the gun that was used, you have a car that potentially puts him there. There's also video of a person of interest walking near the home. They can't really see that person's face. There's the hoodie on, and the person's kind of looking down, so it's not a clear shot of his face, but police or the mayor also have said that they believe that is Michael McKee. Beyond DNA, is there anything else as a prosecutor you would really like to have to put him there potentially in that scene to get to a conviction?
Well, I think that they have what are flock cameras in the neighborhoods, and that's probably where they picked up his car, picked up his license plate and traced it back to him. What I would also be looking to find is cell phones, and everybody has a cell phone nowadays.
Sure.
It
GPS.
pings off of towers that are all around the town, and you can triangulate. And there's an expert at the police department that will testify to these kinds of things. You can triangulate where the cell phone has less pinged, and actually, I had a homicide as a death penalty case as well out in the east side where we actually were, through this cell phone testimony, able to put him in within 200 yards of the victim's home at or around the time of the homicide. And so if they believe, as I have read, the homicide happened between, say, 2 and 5
That's the
a.m.
timeline, yeah.
On the 30th, I think I would find out, and you can subpoena the cell phone providers, all three, and if you find out what kind of cell phone he has, then you focus on them. But that putting him right there with the cell phone evidence, you can literally, within 200 yards of the house between those hours, pin him down there. And that's one thing that I haven't heard about that I think I would be doing.
Yeah, I haven't heard that either, but that would obviously be something that they could do, and it would be a big piece of evidence if they can get that.
Right.
A big question that has not been answered yet, and it's something that everyone seems to always want to know in any case, is the question of a motive. What was the reason for this? Columbus police have described this as a targeted incident, as a situation of domestic violence.
Right.
It's also a case where there was no forced entry in the home, and the two young children of Spencer and Monique Tepe, 1-year-old and 4-year-old, they were in the home when they were killed. The children are not harmed. They were physically okay. We know that Michael McKee and Monique were married back in 2015. They divorced not long after that. The divorce was finalized in 2017. By what we've seen in court records, it had the appearance of an amicable divorce. They were divorced because they were not compatible, according to the records that we have seen. I was told a long time ago that jurors like to hear a story. Yeah. And a motive is always a key part of that story. How crucial do you think determining a motive and presenting a motive at a trial would be in this case?
Well, at least you hit the nail on the head. I have been mystified from the beginning what the motive could be. They've been divorced for 8 years. They didn't have children. They didn't have custody issues, therefore. They didn't have visitation issues. The financial division of property would have been done 8 years ago. So trying to determine why he would drive from Chicago to Columbus to do these murders was beyond me, and still is somewhat beyond me. I have seen some of the internet sleuths theories.
Oh, they're out there. A lot of people saying all sorts of stuff.
But at least the only thing that I have seen that makes some sense is that he's the kind of person that didn't want to see her doing so well and having such a good life, whereas perhaps he didn't think he was on an equal par with her. But it just makes no sense, apart from a double homicide making no sense. But the good news for the prosecution is there's a jury instruction that under Ohio law, the jury would be told is the state need not prove a motive.
That's what about to follow up with you with.
The state need not prove a motive, and at least he was probably suspect number one from the get-go as the ex-husband, because that's where generally investigators go to clear him or to continue working on them. And so he could be eligible, however, for dumbest criminal of the year for keeping that murder weapon for 10 days after the murder at his own home.
Yeah, and police have said, you mentioned ballistics testing, they said that preliminarily it is linked.
Correct. And so in addition to driving his own car here and to commit the crime, both of those things, if you're a very smart criminal, you wouldn't do.
So obviously we should point out, in the justice system in the United States, you are innocent until proven guilty. So the burden of proof is on the prosecution at this point. I know you're not a defense attorney,
Well, I am periodically.
Well, I know you are now, but in the capacity that we're talking to you, and you were not a defense attorney, and you're not attached to this case, but if you were representing Mr. McKee, police say they have a murder weapon. Police say they have the gun. Police say they have his car in the area. We're talking about potential cell phone evidence.
Right.
How would you start to form a defense? What would you look to build your basis from if this was your case? We don't know what Diana Monash is going to do, but what would Ron O'Brien do?
Well, I think that any defense attorney is going to look at the circumstances of, as I mentioned before, the affidavits filed to get arrest warrants, the affidavit in support of the search warrant that searched his residence, which I understood is where they found the gun. Both of those are legal kind of issues, and the goal, especially with the primary piece of evidence against the defendant, is the handgun, would be to suppress that, as evidence and exclude it and not allow the state to use that as evidence. As you know, under the Fourth Amendment, you have to have a search warrant that establishes "quote-unquote" probable cause.
Right.
So I think the first order of business for any attorney would be to review the documents that are on file and which you can obtain from the prosecutor to see if there are any, I guess, legal methods to exclude.
Make sure everything was done in the right way.
That's right. And that would be probably, assuming that that's the murder weapon, I don't know what else you would do other than seeking to exclude the evidence. I suppose they would, given the circumstances we already talked about, look into his mental health, history and status as to why he would drive 300 miles to commit a murder of an ex-wife that he's been divorced from 8 years. There may be psychologists, psychiatrists that provide insight on that, and you may be able to argue something about his mental status, providing a defense. That's going to be very, very difficult. And those are the only two avenues that I could foresee.
This case obviously has gotten so much attention, not just here in Central Ohio, but across the country. National news, national newspapers, national TV. Would you anticipate at all a change of venue request?
Yes, absolutely. Whether it's well taken or not, in a highly publicized case like this, you would ask for a change of venue. And the Ohio Supreme Court has said on a number of occasions that the first order of business is try to select a jury before you grant a change of venue. And then if you bring in the jurors, and you might remember, because you've been here at 6 for a while, the I-270 sniper case that got massive publicity. And when we brought in the jury on that, we seated a jury, and there were, despite the massive amount of publicity, we were able to seat a jury in that case. The one that I always remember is the bass fisherman who was traveling the country in tournaments, who hadn't heard anything about the case. And as I say, every weekend there were warnings saying, be careful driving on our interstates. Oh, yeah,
those warnings were everywhere.
And this fella that didn't know what we were talking about because he was traveling the country.
Wow.
And so he was seated on the jury. And so you have some folks that you in the news business probably don't particularly like, but some people go to their kids' soccer games, they go to church, they go to school, and they pay no attention to what's going on around them. I mean, there are lots of people that do that, believe me.
We're trying to reach those people on YouTube and Facebook and Twitter and other places.
So I think that my experience has been, is despite massive publicity, we've been able to seat juries without a change of venue. Having said that, I'm special prosecutor on the last remaining Pike County case involving homicide of 8 people. That is one defendant's remaining to be tried. And the judge in that case, which was unusual because there's already been a trial, some people have also pled guilty, the judge in that case did grant a change of venue without attempting to seek a jury. So it can happen depending on the degree of publicity that may have existed.
Having said all of that, it is high profile. The evidence is, the early evidence is there. Do you think that there's a decent shot that this will actually be tried, or would you anticipate a plea?
Well, I would say, given the nature of the crime and the attention to it, the state is not easily in a position of offering much of a incentive to the defendant to enter a plea. It probably would be an offer of life without parole, which most defendants don't like to enter that kind of a plea unless they're looking at death sentence as a possibility, which isn't indicted as a death penalty case, even though it's eligible.
I was going to ask you about that.
It would have been eligible both based on the aggravated burglary and then based on the felony murder statute and 2 or more victims. Those are 2 death penalty specifications under Ohio law, and it could have been indicted as a death penalty case. And
but it was not indicted that way, to be clear.
For whatever reason, it was not indicted as a death penalty case. So the incentive to avoid a death sentence by pleading to life without parole is not there. And so at least if a plea is to be worked out in these kind of cases, what you would do is try and find a point at which the defendant thinks he might live long enough in prison to be eligible for parole. I just think that if you give him a 30 to life on each of them consecutive, that would be a 60 to life. I'm not sure how old he is, probably mid-30s.
He's 39, I think.
Okay. What most experienced defense attorneys say is you want to give the defendant some hope that he may someday get out of prison on a case like this. I just don't see the state offering anything other than life without parole. And again, there's no incentive for the defendant to take that kind of plea offer.
We're early, as I've said multiple times in this process. I mean, when would you anticipate a trial if it does happen? Are we talking years away? Because these things seem to get continued quite a bit, but within a year?
I would guess a year. On average, when I was there, most serious homicides, including death penalty cases, were tried within a year to a year and a half of the time the defendant was arrested or indicted. And so I would say sometime in the first quarter of 2027, this likely would go forward. The judge will set a schedule of when certain things have to happen, when the defense has to ask for discovery, when the state has to give discovery, when any expert witness reports have to be presented. The judge will set a pretrial, set a date for Ms. Menashe to file motions, set a date for the state to respond, and then a date to have witnesses come in and talk about whatever information is necessary for the record on the motions, and then set a final pretrial and then a trial date. And as I say, likely that schedule will be set out early on.
You have so many years in a courtroom. Yeah. What haven't I asked you that you think we should have talked about today?
You're very thorough, Mike.
Well, good. I'm trying.
And I really can't think of anything in addition to ask. The main thing that I think most of the viewers, as well as those that paid attention, is that question you ask about motive. I mean, what was this guy's motive? And it just kind of escapes normal circumstances.
Well, that's something we will continue to ask police about, investigators about, the lawyers involved about, and we'll do our best to try to cover it, because this is the beginning and there's a long road ahead before this all wraps up. So, Ron O'Brien, thank you so much for joining us today.
Appreciate it.
We greatly appreciate you, and we will keep you updated as all these developments continue to occur. Stay with us at ABC6 for future updates on this investigation into the Tepe homicides from December of 30th of last year.